Welcome. My name is Charles Kaprowitz. I am the Executive Director for Citizen Initiatives and the Countermand Amendment. In this short video, you will learn how we can restore our constitutional republic, protecting states' rights, safely, quickly, and successfully. James Madison was an American statesman, political theorist, and the fourth President of the United States. He is hailed as the father of the Constitution for being instrumental in the drafting of the Constitution and as a key champion and author of the United States Bill of Rights. He served as a politician much of his adult life. Mr. Madison said the following: "The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. The former will be exercised principally on external objects as war, peace, negotiation, and foreign commerce. The powers reserved to the several states will extend to all the objects which, in the ordinary course of affairs, concern the lives, liberties, and properties of the people, and the internal order, improvement, and prosperity of the state." State legislatures in 1787 created the federal government. The government did not create the legislatures. The legislatures reserved to themselves and future legislatures, in Article 5, the authority to amend the Constitution and modify the conduct of the federal government in order to preserve states' rights. It is absurd to argue that state legislatures must first get the federal government's permission before amending the Constitution. When the legislatures ratify any amendment, it is obligatory on the courts, Congress, executive branch, agencies, and financial institutions, including the Federal Reserve, to obey its provisions. Legislatures are the final arbiters in all constitutional matters. State legislatures can restore our constitutional republic safely with the single-issue Countermand Amendment, which includes pre-approved application by legislatures on Congress, pre-approved countermand text by the legislatures, and a pre-approved delegate resolution that binds delegates. Citizen Initiatives and its team have been the leading authority on the Article 5 amendment process, either through Congress or conventions, for 40 years. Citizen Initiative's mission: to help state legislatures preserve and safely apply their sovereign authority under Article 5 against encroachments by Congress or federal courts, the executive or non-government mandates, regulatory agencies, or delegates sent to a convention. Under Article 5, Congress is the facilitator of the amendment process and provides a manageable transition from applications to ratification. When Congress proposes amendments to the states, they do so as the deliberative body that writes and pre-approves the amendment before it is sent to the states. In the same way, state legislatures are the deliberative body and pre-approve proposed amendments before the convention convenes. State legislatures under Article 5 have sovereign deliberative authority over Congress and the Supreme Court, which assures that their collective will is obeyed by all branches of the federal government. Article 5 of the United States Constitution reads as follows: "The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress. State legislatures, having met their constitutional obligations when 34 state legislatures make applications on Congress, can convene a convention themselves if Congress causes unwarranted delays. State legislatures can safely amend the Constitution with single-issue amendment conventions, but they cannot arbitrarily rewrite the Constitution through delegates at the convention. Legislatures, as the deliberative body, pre-approved the text of all proposed amendments as well as delegate resolutions. State legislatures are the final arbiters in all constitutional matters through to ratification. With the single-issue countermand amendment, legislatures can address egregious wrongs suffered by their citizens. They can do so safely, quickly, and successfully. What is the National Strategy Committee? The committee will identify, select, and countermand laws and rulings that are burdensome to the states and their citizens. The committee is comprised of state legislators and citizens from each state. It includes a steering committee. Citizen initiatives will facilitate decisions of the National Strategy Committee in the 50 state legislatures. The National Strategy Committee avoids likely lawsuits against state legislatures claiming violations of Article 1, Section 10, which prohibits interstate compacts between the states without permission of Congress. What can states countermand? States can countermand and rescind laws and regulations that infringe on constitutional rights, enumerated rights, unenumerated rights in the 9th and 10th Amendments, federal land grabs, deficits, debt, taxation, Federal Reserve policies, and other non-government mandates, health care, energy, mining, local education, social issues, and more. Article 5 is a new beginning for our republic. Article 5 is simply for proposing amendments. It does not allow for a constitutional convention. Article 5 will not produce constitutional conventions. Article 5 does not allow the convening of a constitutional or open convention. This flawed constitutional argument has paralyzed state legislators for 30-plus years. Article 5 allows the convening of an amendment convention to propose amendments. The purpose of Article 5 is to protect the supremacy and perpetuity of the Constitution, and to protect our civil liberties and states' rights. This is the real genius of the Founders and 1787 state legislatures. The simplicity of Article 5 was deliberate. Future legislatures would retain sovereign authority to decide how they should control the amendment process. The Constitutional Convention argument is based on an erroneous claim that the transition from the Articles of Confederation to the new Constitution was a usurpation of power by the delegates over the Articles. After the Annapolis Convention failed, Hamilton and Madison asked Congress to allow an open convention that would have the authority to amend the Articles without defining the limits of the convention. Congress and the legislatures agreed. The Articles did not allow the federal government to function effectively, which almost caused the loss of the Revolutionary War and the peace afterwards. Unanimous consent by the states was the biggest problem under the Articles. All 13 states wanted to retain their sovereign authority. There was no usurpation of power by the delegates. They did not force a transition to a constitutional convention. Legislature sovereignty trumps convention experience, historical experience, legal precedents, and federal mandates. State legislatures alone control the amendment process, from the application to ratification, not Congress, nor the courts, nor the executive branch. Legislatures don't need permission from the federal government to apply for and convene a convention, as long as the purpose is to propose amendments. Simultaneous, multiple, single-issue amendment conventions are allowed in Article 5. Article 5 delegates are not equivalent to the founders. They are ambassadors of their legislatures, not free agents. The founders, who were delegates, were commissioned to create a new constitution and a new government. Article 5 delegates are commissioned to only vote on an amendment pre-approved by their state legislature, thus leaving sovereignty in state legislatures, not delegates. The Article 5 single-issue Countermand amendment will empower legislatures to address egregious wrongs suffered by the people in their states, safely remedy those wrongs one issue at a time when the federal government refuses to do so, give the states a powerful tool to peacefully counter federal encroachment on their states' rights, create effective ways to use the Countermand Amendment among the 50 states, and establish a workable balance of power between the states and federal government. Article 5 does not allow the states or delegates at a convention to write a new constitution. In order for the states to create a new constitution, they would have to secede from the Union, call for a convention independent of Article 5, create a new constitution, and form a new government. Under Article 5, states already have sovereign authority to amend the Constitution to protect our liberties, so secession is not necessary. The Countermand Amendment empowers state legislatures to affirm and secure their sovereign authority peacefully, without changing our inalienable rights and protections in the Constitution. The thorniest problem at the 1787 Convention. 13 state legislatures created the Constitution and federal government. Their purpose was to form a federal government that would serve and protect the states, not for the federal government to rule over them. Their thorniest problem at the convention was resolving how the states would retain their sovereign nation-state independence. The solution was in Article 5. Under the Articles of Confederation, amendments to the Constitution required unanimous consent by the states. This nearly cost us the Revolutionary War. One state could hold the others hostage. Under Article 5, ratification requires only 3/4 of the states. Sovereignty remained in the hands of future state legislatures. State legislatures are the deliberative bodies. Under Article 5, state legislatures are the deliberative body, not delegates they send to a convention. State legislatures defined their sovereign authority under Article 5 for themselves and future generations of legislators, and they must not abdicate it, not to Congress, not to the courts, not to the executive branch, not to the Federal Reserve or other private entities, not to regulatory agencies, not to delegates they send to an Article 5 convention. Most Article 5 groups will cause abdication of state sovereignty. Most Article 5 groups are ignoring critical constitutional matters that diminish, even cause abdication of state sovereignty. Their Article 5 process will make it impossible for future generations of legislators to retain their sovereign authority and prevent them from using Article 5 successfully in the future. Legal precedents will not guarantee that an Article 5 convention will be governed safely. Convention experience before the Constitutional Convention can't cause a convention to be conducted safely. Historical experience will not guarantee that deliberations at an Article 5 convention will be productive. Delegates to an Article 5 convention are not sovereign. There's no mention of delegates in Article 5. Only a delegate resolution, pre-approved by state legislatures, will assure a safe, quick, as short as 7 days, and successful Countermand Amendment Convention. State sovereignty was the most important issue at the convention. Convention rules were proposed by Delegate George Wythe even before deliberations by the delegates started. Proceedings were to be secret, guards to be placed at the doors, credentials required for the entrance, each state to have one vote at the convention. 30-plus previous state conventions did not decide this question for the founders. Politics did. It will have to be decided again and again at every Article 5 convention. The Countermand Amendment Delegate Resolution requires the convention be organized as a republic. Each state will have one vote. All decisions will be decided by a simple majority vote of state delegations, not by the population of states. Polls of delegate positions not recorded. Delegates speak only twice. Delegates pay strict attention and remarks are addressed to the President. "534 politically charged delegates may be summoned by Congress and appointed by legislatures to an Article 5 convention. Issues they will have to decide include how the convention should be organized, what rules of order will be used, will Article 4, Section 4 be used to guarantee a Republican form of convention, will one vote per state be adopted at the convention, or will voting be based on the population of each state? Will majority rule be used at roll calls? Will delegates be bound to their legislatures? What subjects, sub-subjects, sub-sub-subjects, etc. will be considered? How will the delegates identify federal encroachment on states' rights? Which delegates will decide the final text of a proposed amendment? The Countermand Amendment Delegate Resolution will assure that the convention is safe, quick, maybe as little as 1 week, and successful according to the collective will of state legislatures. The Countermand Amendment will avoid a lengthy and disruptive convention. A pre-approved Countermand Amendment text with delegate resolution will prevent 534 politically charged delegates from delaying and disrupting the convention. The Countermand Amendment convention can actually finish in as little as 7 days. With the Countermand Amendment delegate resolution, there will be no drawn-out deliberations or wrangling at the convention. Other Article 5 amendment proposals could take 12 months or longer, and there is no guarantee that they will ever come to any agreements acceptable to 38 ratifying states. It could take years before any ratified amendment is effective for reining in the federal government. The Countermand Amendment solves all of these convention problems and almost every other issue relating to federal encroachment on states' rights, including prohibiting Congress from excessive or deficit spending. The nonpartisan Countermand Amendment provides tools with teeth for state legislators. The nonpartisan Countermand Amendment protects states' rights by empowering states to disallow and rescind burdensome federal laws and rulings imposed on their citizens, businesses, and industries. Once 60% of states complete a countermand on a federal law or ruling, it is immediately rescinded. Existing laws and rulings can also be countermanded. The Countermand Amendment has tools with teeth for state legislators. Intentional violators of the provisions of the Countermand Amendment are subject to criminal prosecution. Government officials and employees are subject to criminal prosecution. Elected officials, non-government workers, and entities. Enforcement can be by the federal government or by state governments under state laws in the absence of federal prosecution after 90 days from the date of the alleged violation. Multiple prosecutions by multiple states for the same alleged crime are prohibited. States will be respected as partners by the federal government. With the Countermand Amendment, the federal government will see the states as partners in government and not subjects to federal mandates. All branches and agencies of the federal government, including private entities such as the Federal Reserve, will be subject to the collective will of 60% of the states. When the states countermand and rescind a law or regulation, the federal government will have to either rewrite the law in a way more amenable to the states or simply abandon it. With the Countermand Amendment, a workable balance of power will be reached. State legislatures will be able to restore our constitutional republic with the Countermand Amendment. The Countermand Amendment and individual state nullifications complement each other. States can exercise individual nullifications with or independent of the countermand. With countermands, the states can safely and peacefully define and protect their unenumerated rights in the 9th and 10th Amendments. Other amendments that can be protected include the First Amendment, Second Amendment, land grab issues with the regulatory agencies, energy issues, environmental issues. Countermands are an act of nullification. When 60% of the states countermand a law or ruling, it is rescinded peacefully. The federal government will not be able to enforce a rescinded law in the future. Steps in the Article 5 Countermand Amendment process. 34 state legislatures complete applications directing Congress to convene the Countermand Amendment Convention. Because legislatures are sovereign under Article 5 and will have met their constitutional requirements, Congress is now mandated to convene the Countermand Amendment Convention when the 34th state completes its application. Applications must be near identical between calling states, especially the titled Countermand Amendment Convention. State applications are expected to be completed by late 2015 or early 2016. "26 or more states must approve a similar Countermand Amendment Delegate Resolution. Adoption of the Delegate Resolution must be before the Convention convenes. The Delegate Resolution is a contract between the legislature and their delegates going to the Convention. It avoids possible conflicts with Article 1, Section 10, prohibiting interstate compacts between the states without Congress's approval, which we want to avoid. The Countermand Amendment Convention is now safe, quick, maybe only 1 week, and successful. 38 state legislatures must ratify the Countermand Amendment, which could be completed by early 2016. Individual countermand initiatives can begin by state legislatures in late 2016. State legislatures alone have sovereign authority under Article 5 to make applications for a convention and to ratify amendments without the consent of Congress, the courts, executive branch, regulatory agencies, or delegates. Legislatures make applications on Congress calling for a single-issue Countermand Amendment Convention. Legislatures define the agenda, rules of order, and amendment text for the delegates to follow at the Countermand Amendment Convention. Legislatures bind delegates they send to the convention with the delegate resolution. Legislatures send delegates to a convention as ambassadors, not free agents. Only 3 documents are needed to assure that the Article 5 single-issue Countermand Amendment process will be safe, quick, and successful. The Countermand Amendment itself, go to countermand.us/countermand-amendment.html. 2. The application on Congress calling for a single-issue Countermand Amendment Convention. Go to countermand.us/countermand-on-congress.html. The third is the delegate resolution to bind the delegates, which includes the text for the Countermand Amendment. Go to countermand.us/countermand-delegate-resolution.html. 26 or more states must adopt the delegate resolution with near identical instructions to their delegates to assure a successful convention. Presently, we have 15 sponsored states for the Countermand Amendment. We hope to have 34 during the 2015 legislative session. The text for the amendment in Section 1 and 2 reads as follows. The article restores state sovereignty in our constitutional republic by providing state legislatures countermand authority. Section 2. State legislatures in the several states shall have the authority to countermand and rescind any congressional statute, judicial decision, executive order, treaty, government agency's regulatory ruling, or any other government or non-government mandate, including excessive spending and credit, imposed on them when, in the opinion of 60% of state legislatures, the law or ruling adversely affects their state's interest. When the countermand threshold has been reached, the law or ruling shall be immediately and automatically nullified and repealed. This countermand authority shall also apply to existing laws and rulings. The Countermand Amendment application and delegate resolution must be approved by 26 or more states. The Countermand Amendment enforcement provision is in Section 5 and 6. Section 5 reads, any elected or non-elected government official or non-government individual or organization who intentionally obstructs or prevents the implementation of any provision in this article shall have committed a criminal offense and shall be subject to impeachment, when applicable, and criminal prosecution, and upon conviction serve up to 5 years in prison. Section 6. Individual states shall have authority to prosecute violators of this article under state laws in the absence of federal prosecution after 90 days from the date of the alleged violation. Multiple prosecutions by multiple states for the same alleged crime are prohibited. The application on Congress for the Countermand Amendment Convention can be found at countermand-us/countermand-on-congress.html. The application on Congress for the single-issue Countermand Amendment Convention should have the same title and similar text for all calling states, especially the 60-day requirement for Congress to convene the convention. it should not include the text for the amendment or delegate resolution. The Countermand Amendment application on Congress. Congress does have the responsibility to defend the Constitution against all enemies, both domestic and foreign. This is why the applications from the states directing Congress to convene the Countermand Amendment Convention must not be ambiguous, and their stated purpose must be in unison between the states. All calling states need to include the identical title, quote, Application on the United States Congress calling for the Countermand Amendment Convention. You can get a template that other state legislatures are using by going to countermand-us/countermand-application-on-congress.html. The requirement that Congress convene the convention within 60 days of receiving the 34th application from the states must also be included. When 34 state applications for the same specific amendment convention are delivered to Congress, then they are no longer applications, but rather mandates on Congress to convene the convention. The Countermand Amendment Delegate Resolution can be found at countermand.us/countermand-delegate-resolution.html. It is important that the calling states have a similar, if not identical, delegate resolution, which will contain the instructions from their state legislature to their delegates, binding them in a similar way from one state to the next in the instructions in the resolution. The delegate resolution must be approved by 26 or more state legislatures to assure a safe, quick, and successful Article 5 Countermand Amendment Convention. The delegate resolution does not violate Article 1, Section 10, prohibiting interstate agreements without the consent of Congress, which we must avoid. It is a contract between a state legislature and the delegates it sends to the Countermand Amendment Convention. When 26 or more states give the same instructions to their delegates, then the Countermand Amendment will be successful. The states must not abdicate their Article 5 sovereignty to Congress, the courts, or the executive. Governors have no authority under Article 5. We are making history with the Countermand Amendment. Thomas Jefferson once said, God who gave us life gave us liberty. Can the liberties of a nation be secure when we have removed a conviction that these liberties are the gift of God? Indeed, I tremble for my country when I reflect that God is just, that his justice cannot sleep forever. Be part of this historical, nonpartisan initiative that can permanently restore our constitutional republic through state legislatures. You can contact us at Citizen Initiatives, P.O. Box 523, Spruce Pine, North Carolina, 28777. You can also contact our director at countermands.us.